Hello, welcome to this recording about unfair dismissal. Now, this is an interesting topic because most people have some idea that actually you do have a right to be protected in the workplace and you can't just be got rid of for any old reason. However, it's quite often a bit confused, they're a bit hazy in their understanding of what the rules are. Now, the rules for this are contained initially in the Employment Rights Act, which has been amended from time to time, the latest act being 2008. Now, this says that any employee who feels they've been unfairly dismissed can bring a claim before the Employment Tribunal. Now, this piece of legislation creates the right of action for unfair dismissal, and the only way you can bring your claim is by complying with the various steps set out in the legislation. And one of those is that your claim will go to an employment tribunal and not to an ordinary civil court. Now, in order to show that you qualify for unfair dismissal, you have to meet these criteria. So we've set them out in steps. So first of all, the employee must show that he's a qualifying employee, that he meets the criteria in the Act. So first of all, he must work in Great Britain, mustn't have been dismissed while he was on unofficial strike. You may remember a little while ago when the British Airways staff walked out and their employer's instant reaction was to sack them because they were on an unofficial strike, they hadn't followed the right processes to set themselves up for an official strike, and therefore they weren't protected. You must have been employed for 2 years. Okay, so from your start date to the date when you're dismissed, there must be a 2-year period. And we don't count any time when you were actually out on strike or if you're on active service. You must also bring your claim within the time limit, within 3 months. There is scope for employers to agree to extend this, but I mean, practice, why would they? If you're out of time to bring an action, they're not likely to help you there. The second thing the employee must show is that they've been dismissed. Now, that sounds obvious, doesn't it? Clearly you're dismissed if your employer tells you to go away and never darken his door again. And that's the case whether you are given appropriate notice or not. That's different to wrongful dismissal, which we were looking at earlier. However, you are also dismissed if you have a fixed term contract which is not renewed. Now, that is not the same as being an independent contractor. A fixed term contract, you're an employee, but for a fixed period. And then finally, constructive dismissal. So constructive dismissal is something which we need to have a little look at. So constructive dismissal occurs where your employer has actually breached the contract so significantly, a big breach, if you like, what we call a repudiatory breach, so much that you don't feel that you can work there anymore, and as a result you resign. Now, there's been lots of cases on this, and the courts have said you have to show these 3 things in order to show that you have been constructively dismissed. First of all, that the employer breached the contract, and it was a serious breach. So we're looking at things like reducing your pay, completely changing your job and the role that you do, not providing you with a suitable or safe working environment, little things like passing you over for promotion, not giving you an advance against your holiday pay, things like that, they are not going to be sufficient to amount to a serious breach of contract. Once you've shown that this serious breach has happened, you have to show that you left as a result of that breach, and that you haven't waived the breach. So if your employer does something that you consider to be a repudiatory breach, you really need to take action quite quickly, because if you wait too long, it may appear that you have accepted the change in your employment terms, and therefore you won't be able to argue that they made you leave the workplace. If it turns out that actually you left the workplace because you had a better job elsewhere, you're very unlikely to be able to claim constructive dismissal successfully. Now, once you have shown those things, you've shown that you're within the scope of the legislation. So to recap, you meet the criteria to be a qualifying employee and you have been dismissed. The employer must now show that, yeah, okay, he did get rid of you, but he did it for a fair reason. He had a good reason for letting you go. The purpose of this legislation is not to say that employees can never get rid of staff. It's just saying that they need to do it carefully and fairly. So what might be a fair reason? Well, first of all, capability or qualifications. So if he's getting rid of you, for instance, because you failed to pass your ACA exam, there must be a contractual obligation to pass that exam. And if you check your training contracts, lots of you will see that if you fail an exam more than a certain number of times, your employer has the right to dismiss you. Also, capability. So this is your ability to do the job. Now, the level of ability they're looking for here is the level of ability that you said you might have at the interview. What did you let them know you were capable of? And also, there'll be a minimum level, a sort of core level of competence that is required for your job. And to decide this, we might look at your fellow employees, what standard they reach, and what the contract requires, as well as your previous performance. Now, it will vary from job to job what level of capability is acceptable. For instance, there was a case of an airline pilot who landed his plane negligently. Now, to be honest, you've only got to make that kind of mistake once and you could kill lots of people. So it was perfectly reasonable on this occasion that the airline dismissed him for that one error on one occasion. In another job, perhaps a small error might not have such huge consequences, and therefore you'd expect an employer to be a little bit more tolerant. You could also be dismissed because of your own misconduct. Now, the employer doesn't have to show that you were guilty, just that he genuinely and reasonably believes that you were guilty. Some examples there: abusive language, theft. Even if it's something small, you can still be dismissed for theft, even if it's just that package of post-it notes. Dishonesty, violence, downloading pornography. Sexual harassment, persistent lateness, persistent absenteeism, i.e. lots of sick days that you weren't justified. Okay, another potentially fair reason to get rid of someone is redundancy. So if you're getting rid of someone in a redundancy situation, that's fair, you're allowed to reduce your head count. However, you have to show that you selected that person fairly. So, for instance, you had a fair selection process, followed procedures. You didn't select someone for an unfair reason, such as their pregnancy or collection with a trade union. And ideally, that means you followed the ACAS guidelines. And they say that as soon as an employer is going to make redundancies, he must warn the staff who are potentially at risk, even if he hasn't quite decided who's going and who's staying yet. You must consult with the trade union or with the staff if there is no trade union. Verifiable selection criteria. Fairly applied. And if he can make an offer of alternative employment, he should do so. So this is if he can offer you another job elsewhere in the business. Okay, two more categories of potentially fair reason to look at. What about statutory restriction? Basically, you are no longer legally allowed to do that job. Perhaps you're a director of a company and you've been disqualified under the CDDA. Perhaps you're a doctor who's been struck off with the medical council, or maybe a lorry driver who's lost his driving licence. Obviously, you're no use to the employer and they'd be justified in getting rid of you. Or you've got some other substantial reason. Now, this is the sort of thing where it's a catch-all category, really, where the firm can show that it's not within one of the existing justifications, but in their particular circumstances, it does seem reasonable. So one of these, which I always think is slightly unfair, is where the employee was married to an employer's competitor. They were worried about confidential information being passed on. Another one is where you've perhaps made a change in the way you carry on your business, in this case a change in work patterns and shifts, and you've got that one employee that just won't conform. Everybody else has adapted beautifully, but this one person just won't fit in. Where the employee's activity, in this case paedophile activity, has damaged the reputation or could damage the reputation of the workplace. A word about age. It's really difficult now because the Equality Act has said that it is not possible anymore to discriminate on the grounds of age. So that means things like forcing a retirement age becomes incredibly difficult. So it is sometimes possible to justify getting rid of someone on the grounds of age, but you'd have to show that that made it difficult for them to do their job. And as it says there, that it was proportionate and objectively justified to get rid of that person. In real life, rather than the exam world, if you are thinking about getting rid of someone on the grounds of their age, you need to be very careful how you go about that, and you'd probably take legal advice, or at least advice from your HR department. Generally, to get rid of someone on the grounds of their age, you'd have to show that it affected their capability to do the job. Okay, so the next step, again, this is on the employer. And the employer must show that not only did he dismiss you for a good reason, one of the reasons we've just looked at, but also that he behaved reasonably and followed all procedures. Now, this won't stop your dismissal being fair, but what it can do is result in extra damages. So the employer has to show that he followed his relevant procedures, and that might be the internal disciplinary procedure, or it could well be ACAS guidelines, which are now a statutory obligation to comply with those. He's got to show that he took all circumstances into account. So, for example, have you been ill for a while? Has he given you time to recover? Were you given suitable support? Could you have been given training, for instance? And to evaluate all this, we're looking at what would a reasonable employer have done? Well, this will depend slightly on the size and type of organisation you're working for. A big organisation has a lot of resources that it can put out to help improve its employees' behaviour. A smaller firm may not be able to do that. So things like time for improvement, giving you a mentor, sending you on a course, things like that. What would they normally do, and what would a normal employer of that type have done? Now, case is just there to illustrate a point, really. I mentioned earlier that, of course, the unfair dismissal rules do not mean that an employer can never dismiss you, just that they have to behave reasonably and fairly. So in this case, an employee had been off sick for quite a long period of time. He was given 6 months to improve, and given a warning that, if he didn't get better in 6 months, he would have to be dismissed. The employee claimed unfair dismissal, but the court said, look, the employer had acted reasonably. He'd waited long enough, he'd given him time to improve, and he couldn't be expected to keep that job open forever. Now, some people in the workplace are considered to be particularly vulnerable, and we call these people who have the protection from the automatically unfair dismissal rules. These rules say that if you are dismissed for one of these reasons, then your dismissal will automatically be unfair. There is no need for a minimum employment period. You are protected from day one. Indeed, if you were offered a job and it was subsequently revoked for one of these reasons, you would also have the protection of the legislation. So what are these conditions? You need to learn these if you can. The examiner likes to test these. So if you are dismissed because you're pregnant, or because of a pregnancy-related illness, for instance, or because you're taking time off for antenatal treatment, that's one just for the girls, I'm afraid. If you have what we call a spent conviction, so the Rehabilitation of Offenders Act says that if you're convicted of an offence, after a certain period of time that offence will drop off your record, a bit like points on your driving licence. And therefore, after that period, for many professions, there's no obligation to disclose it. However, if your employer then finds out about an offence that is regarded as spent under the Act and sacks you as a result, you could treat that as automatically unfair dismissal. If you are dismissed because of your trade union activities, so long as it's official trade union activities, you get very little protection under the employment legislation if you are on unofficial walkouts and strikes and so on. Transfer of undertaking, this is where one business takes over another business. They're not allowed to say, well, I haven't employed you for very long, and therefore I am now going to sack you. Because if they've taken over an existing business and you had protection in the existing business, that will carry forward into your new role. It doesn't mean, again, that following a takeover you can't be dismissed, but they'd have to show that there were justifiable reasons for doing so. Protecting yourself or your workplace, your work colleagues from imminent danger. So this is really about health and safety type issues. If you think that your employer has unsafe work practices and you try and do something about it, then you would be protected under the Act. Trying to enforce your statutory rights. So for instance, if you asked for the minimum wage and the very next day your boss decided to get rid of you as a troublemaker, you would be able to claim that your dismissal was automatically unfair. And of course, the whistleblowing legislation. If you are dismissed after making a disclosure which is a protected disclosure, again, you will be treated as automatically unfairly dismissed. And remember, in this case, you will get unlimited damages. There's no cap on the damages that can be awarded. Now, of course, you'll be trying to show the tribunal that you were dismissed for an automatically unfair reason. But your employer might say, no, I didn't get rid of them for that reason. Yes, this person is pregnant, but I got rid of them because of their capability to do the job. So you can expect a battle when you're trying to show that you were dismissed for one of these grounds. Have a look at the unfair dismissal interactive question now. Just pause the recording for a second. Okay, so have a look at these. Dismissal will constitute unfair if it's on the grounds of pregnancy. That's an automatically unfair condition. Enforcing the minimum wage or trying to enforce your statutory rights, also automatically unfair. On the grounds of retirement, you'd have to ask quite a lot of questions to answer that one, so that goes in the maybe category. It's potentially age discrimination and therefore unfair. Is it due to the employee taking part in unofficial industrial action? The answer there is no. If it was official industrial action, then that would definitely be unfair. But if it's unofficial action, there is no protection offered. Okay, so we're almost there now. Remedies for unfair dismissal. So if you've managed to prove your claim, you've shown that you are a qualifying employee, you were dismissed, your employer hasn't managed to show that it was for a potentially fair reason, and that he behaved reasonably, you now have the option to claim your remedy. Now, the first two remedies are pretty rarely used. Reinstatement is a court order or an order by the tribunal that you can go back to the same job. Now, most people, if you've got to the point of going to the tribunal, you're probably not going to want to do that. It's quite good for people like dinner ladies maybe and lollipop ladies, people like that, who are actually employed by, say, the council, but actually don't work with the people who are their direct employers. Re-engagement, this is an order that you're given a new role with the same employer but a different job. Again, unusual for that to be used, but it's there. The main remedy is likely to be compensation. So compensation is awarded in various categories. The legislation has a maximum which changes each year. You don't need to learn this maximum, but it puts a cap on the amount of damages that you can actually get. So your first one is a basic award, and that's linked to your length of employment, how long have you been there, your salary level, although again subject to a cap, and your age at the time you're dismissed. So if, for instance, if you are over 40, your payment will be 1.5 times your weekly salary subject to the statutory cap. Compensatory award. This is meant to cover you for things that you, extra benefits and so on that you might have lost. It's a bit more like the damages you might get under contract law. So things like loss of earnings for the time it takes you to find a new job. Maybe expenses, loss of benefits, things like healthcare and things like that you're going to have to start again with a new employer. Note, because these damages are a bit like the common law damages, the contract damages, you do need to mitigate your loss. So I would suggest you look for a new job, but perhaps not too hard. Finally, there is an additional award. Now, this additional award is meant to be punitive. It's meant to punish the employer if they haven't complied with one of the orders that the court has made, perhaps for reinstatement or re-engagement. Again, it's not that often used, mainly because the reinstatement Orders are quite rare. But it's there, and it's potentially can be imposed on employers. Okay, so that brings us to an end of the chapter on unfair dismissal. It's very useful to know this one well. It gets tested quite regularly, and make sure you understand it. Take the time when you finish this whole chapter to make sure you understand the differences between unfair dismissal, wrongful dismissal and redundancy, because that's quite important.